We're going to resume the session. Welcome, Mr. Pratt. Good morning. Would you please read the statement that, as an expert?
I solemnly declare upon my honor and conscience that my statement will be in accordance with my sincere belief.
Thank you, Mr. Foster.
Thank you, Dr. Pratt. I'd like to ask you a couple of questions about some of Dr. Spiller's criticisms of your work. First, he criticizes your selection of the 12.9% discount rate to be applied to RDC's sunk cost to return RDC to the same financial position it would have been in the absence of Lesivo. Please explain to the tribunal why you believe that RDC's sunk cost should be compounded at that rate.
I chose a 12.9% for a discount rate to discount back their future losses, projected future losses, to the December 31st, 06 date. And since they'd already been investing, they had to compound their investment up to the same date at the same rate, so that the two would balance off. In other words, the amortization would equal the value of the sunk costs, and so that's the reason for it.
Now, Dr. Spiller also says that compensation cannot be computed based upon the amount invested because a significant portion of the amounts contributed by RDC and other investors to FVG were used to cover operational losses. Would you please comment on whether or not it is appropriate to consider the monies that were spent to cover operational losses as an investment which should be recovered by RDC?
The answer is yes. RDC or FEG FVG was a startup company, and the startup companies often incur losses in their early years in order to get going, and especially a railroad. So that was entirely appropriate to consider those operating losses as part of their sunk costs.
Now, turning to the dispute over the proper discount rate, Dr. Spiller criticizes your selection of RDC's cost of debt as the appropriate cost of debt for the computation of the weighted average cost of capital. Would you please tell the tribunal why you chose RDC's cost of debt?
Well, because that was in fact what they were paying. Mr. Spiller would have them immediately from the time of the Lesivo, would have them turn to local sources, but that would be uneconomical because local sources can't lend at those rates. RDC operates railroads around the world and finances all of them at the same rate, and you can be sure that the lender takes into consideration what the money's being used for, how risky it is.
Dr. Spiller, in that same regard, Dr. Spiller makes a big point of the fact that FVG operated in Guatemala and thereby faced a higher degree of long-term economic instability. Would you comment on that criticism?
Well, we added a company risk factor to our equity rate, and certainly the lender recognizes these risks in its establishing its lending rate.
Now, turning to the issue of the cost of equity, Dr. Spiller says that your estimation of the cost of equity is flawed because you use the factor for the 10th decile of company size, which according to Dr. Spiller, does not adequately reflect troubled and distressed companies like FVG, whereas he uses the factor for subgroup 10B, which he says does reflect adequately troubled and distressed companies. What is your response to that criticism?
Well, it's a little bit technical, but Dr. Spiller uses only Morningstar for his data input. I use both Morningstar and Duff & Phelps. Now, Duff & Phelps does screen out the distressed companies because so that's not an issue with Duff & Phelps. But Morningstar takes all the companies that are actively traded on the New York Stock Exchange, American Stock Exchange, and NASDAQ, and ranks them on their New York Stock Exchange share price times number of shares outstanding, common shares, and therefore the aggregate value of the common equity becomes the size, measure of size. Well, a lot of companies have fallen into that size category, not because they're small, but because they've fallen on hard times. And so we at Shannon Pratt Valuations use only the decile 10 when we're using Morningstar. And that also has the distressed companies in it, the same as 10B, because 10B is the lower half of decile 10. But they don't have as much weight because they're diluted by the inclusion of upper half of decile 10. And my understanding is that they intend to take them out, take the distressed companies out, like Duff & Phelps does, but they haven't done it yet.
Now, Dr. Spiller spends a large portion of his report saying that the claimant's damage calculation, including both sunk cost and lost profits, results in double counting. You dealt with that in your report, and please tell the tribunal what you think about that criticism.
Well, whether that criticism is spot on is up to the tribunal. It's not up to me. But the circumstances are that when expropriations take place in an unlawful manner, it would be not in the interests of encouraging good behavior, so to speak, good economic behavior, to just let the company get off with lost profits. In other words, the practice of recovery of investment plus the recovery of lost profits is a significant deterrent to bad behavior economically.
Thank you, Dr. Pratt. Now, if you'll answer any questions that Mr. Debois may have for you representing Guatemala.
Mr. Debois.
Thank you, Mr. President. Good morning, Dr. Pratt. My name is Whitney Debevoise, and I represent the Republic of Guatemala, and I'll have a few questions for you today. Let's start with your report. If we could just put up the first page, or the first paragraph of the report. And blow up the description of the assignment. As I understand it, sir, you were asked to opine essentially on 3 items. A discount rate at which projected cash flows should be discounted back to present value as of December 31, 2006, an appropriate prejudgment interest rate, and whether the methodology of seeking recovery of both sunk costs and lost profits is consistent with economic principles and does not result in double counting. Is that correct?
Yes, that's correct.
Why don't we start our conversation with the last item, the methodology of seeking recovery of both sunk costs and lost profits. And by that, I refer to the sum of these two concepts, because that is, in fact, what was done, although there was an adjustment. You state in the first paragraph on page 1 of your report that you were asked to opine on whether the methodology of seeking recovery of both sunk costs and lost profits is consistent with economic principles. Do you see that?
Yes.
Okay. You then address this question in part 4 of your report on pages 12 and 13. So why don't we move to page 12?
Adrian, does he have the crossbar?
Can we have the screen? Okay. Okay. Interestingly, you begin the discussion of this subject with reference to a legal standard, not to an economic standard, don't you? You cite the Chorzo factory case in the Permanent Court of International Justice, right? Page 12. Maybe we could just blow up the first sentence, if it would be a little helpful to Dr. Pratt. Oh, we can't highlight it. Okay. I apologize, Dr. Pratt. Apparently we don't have the highlighting capability on this document. I'm just referring to the first sentence in your analysis here.
I could read it if you didn't keep interrupting me. Okay.
So my question was, do you agree with me that you begin the discussion of this subject by reference to a legal standard, not to an economic standard?
Yes, I get that's right.
Okay. And I think you recite the holding of that case, namely that the reparation must, as far as possible, wipe out the consequences of the illegal act and reestablish the situation which would, in all probability, have existed if that act had not been committed. Do you see that at the beginning of page 12?
Yes, well, I recall that.
Okay. Now, if we were to look at this Chorzo factory case, which you cited there in footnote 9, in applying the principle of full reparations, the decision focused on value, the value of an undertaking. And that's where you and the experts come in, really, right? Your job is to help the tribunal ascertain this value. Is that right?
Yes, that's right.
Okay. And it's the value of Ferrovias at the time of what we're referring to in this case as the Lesivo Declaration, the alleged expropriatory act. Is that right?
Well, that's right to a point. In other words, it's not just the value as of that date, it's the value of that date as of that date plus the sunk costs.
I think, isn't that the question that we're being asked to address here, is we're trying to find out whether it's consistent with economic principles to have both sunk costs and a discounted cash flow analysis.
Yes, and as I testified, that's not for me to decide, that's for the tribunal to decide.
Right. Okay, thank you. And in terms of the valuation technique that was used by Mr. Thompson, because he did do this addition that we're talking about, do you agree, Dr. Pratt, that the fair market value of Ferrovias at the time of this Lesivo Declaration is given by the expected cash flows that it would generate?
Yes.
And that the fair market value of Ferrovias is the price at which a willing buyer and a willing seller would agree to change ownership of Ferrovias?
Yes.
Okay, thank you. Because that's exactly how you describe it in Chapter 28 of the book that you and Mr. Grabowski wrote on the cost of capital, which has been
yes.
used. So would you say that the discounted cash flow method is the gold standard of methods used to determine fair market value?
Yes.
Okay. I think Mr. Thompson agrees with you on that, and he compliments Dr. Spiller in that regard, saying that he agrees with Dr. Spiller on that. So it's nice to know we have so much agreement here this morning. Now, so basically then you would agree with Dr. Thompson that the value of Ferrovias, absent the Lesivo, would, at least as calculated by Dr. Thompson, using the discounted cash flow method, be $30.1 million.
That's correct. There may have been some shutdown costs after that.
All right. And if the value of Ferrovias, using the gold standard evaluation, generates a certain number, a certain value, why would Dr. Thompson be correct in adding more to it? At best, his net capital contribution method should be an alternative method of valuation, not a method that produces a value to be added to an already calculated discounted cash flow value, right?
Well, not necessarily, because if you did that, it would be an incentive for governments to invite investment in their country and then snatch it away just when it was becoming profitable. In other words, the inclusion of the sunk costs is an economic deterrent for governments to act badly, and therefore now, in fact, Mr. Thompson does amortize those sunk costs over the life of the investment, and so that it comes out even. It's the same amount that's amortized is what was on the books or spent and move forward at the discount rate, and they balance each other out.
But if I could go back to the beginning of that last answer that you just gave, essentially you were talking at that point about the legal decision that you think the tribunal needs to make based on policy considerations. Is that correct?
Yes.
Okay. And if I were to tell you that let's just leave it there for a minute. Now, do you believe that the net capital contribution method by itself, in this case, would overcompensate the claimant? Did you examine the financial results of Ferrovias as they appear in the financial statements and the annual reports?
There were two questions in that, but I think the answer to both of them is yes, I believe. What was your first question?
Yeah, the application of the net capital contribution method by itself alone, in this case, would overcompensate the claimant.
No, I think not.
Because when Dr. Thompson did that, he came up with a value of some 42 odd million.
Yes, I believe he did, and that was amortized over the length of the contract.
Right.
Charged off as an expense of a little over $1 million a year.
Right. Well, we'll get to that in a minute. But when you looked at the financial statements, there were nothing but losses from the time of inception, right?
Yes.
And how long a period was that? That was about 8, 9 years, no?
Well, about 7 or 8.
Right. And there were lots of new capital contributions to cover these losses, because I think you were asked a question about that by counsel.
Yes, and there were still investments to be made, and RDC was still making investments in FGV at the time and after the breach.
And Mr. Thompson, by using the net capital contribution method with updating to the date of the taking using the weighted average cost of capital that you calculated, has given the investor in Ferrovias a compound rate of return of 12.9% for the period, and that was during a period when they had nothing but losses.
That's correct.
Okay. But that doesn't return the investor to the same financial position it would have been in absent Guatemala's breach, as you say on page 13 of your report, does it? In fact, it would put RDC in a much better position.
Well, no, it would have put them in a position to recoup their losses, but wouldn't put them in a position to be the beneficiary of the future profits.
Now, you indicated in your report that a correction for double counting was appropriate. I think that was on page 13 of your report. if we look at the second paragraph on that page, so in the second half of that sentence in that paragraph, you said that when the income stream is limited to a finite number of years, then the investment must be recovered and amortized over that number of years, i.e. annual deductions from the projected cash flows, right?
That's what Mr. Thompson did, yeah.
Right. And well, and I think you were saying that you think that that's appropriate.
Yes.
Yes. And you go on to say that Dr. Thompson has indeed amortized RDC's sunk costs over the remaining life of the contract, and that therefore there's no double counting. Do you see that?
Yes.
Okay. Dr. Pratt, would you say that what Dr. Thompson has done here is a standard, excuse me, a standard practice in valuation?
Well, depends on how you look at it. He looked at it as to you had to recover the invested cost or the sunk cost, plus you had to recover your lost profits. And like I said, it's up to the tribunal to decide whether that is reasonable or not in the interests of justice and economics, because if you don't do that, as I testified, you invite states to invite investment and then snatch them away. So that's not a standard method, but it's a method when that set of facts and circumstances abides.
Okay, so it's not a standard method.
Well, the standard method when you're faced with that situation.
And the amortization that was done on a straight line basis, correct?
Yes.
Right. So it, over the life of the rest of the usufruct that Ferrovias had, if we were doing using net present values and so forth, there would be a much bigger portion of what had been added on, which is not in fact amortized.
I don't think that's correct. I think it's fully amortized.
Fully amortized perhaps in a narrow accounting sense, but not in an economic sense, correct?
Well, I'm not an economist, so I don't speak for economists. But it's net present value at 12.9% is indeed less than is indeed less by deduction than the sunk cost.
And
In other words, the deductions turn out to be less than the sunk cost because of the timing.
And again, back in the beginning, I think you stated in your statement that basically your mission was to determine whether all of this had been done consistent with economic principles. So I understand you're not an economist, but we are talking about economics here.
Okay.
Yeah. Now, would a willing buyer pay the present worth of future benefits plus the amortized sunk cost, or would they just pay the present worth of future benefits?
Well, the question is that the standard of value? I don't think that's the standard of value here. The standard of value is, in my opinion, the standard of value is not fair market value. The standard of value is something else.
But when you give me that response, again, you're assuming that the tribunal might rule a certain way on the standard.
Yes.
Standard valuation would be the fair market value, correct?
The numbers are all there if they decide that they want to, as I said many times, that's up to the tribunal, and the numbers are all there in case they want to work it out.
If they want to punish Guatemala, they can do that.
Yeah.
Okay. Let's talk about the cost of debt. The section of your report concerning the cost of debt in the weighted average cost of capital calculation, I think we should turn to page 11 of your report. Could we scroll a little bit more? We need the heading at the top there that says cost of debt. Yeah, there we go. Can we just blow up? Oh, I guess we have no ability to blow up on this one?
We can blow up.
Okay. Okay, fine. Thank you. All right, so we're going to talk about this cost of debt. You assume that RDC would continue, as it has in the past, with a pre-tax borrowing cost of 7.08%. But is that not one of the common mistakes in valuation? If we're going to measure the cost of debt of the willing buyer would not look at his own cost of debt, but rather the cost of debt of the target company, the company that he intends to acquire, right?
No, that's not generally true in these situations. It's true in these situations that companies do finance other countries' construction and so forth, and they do borrow in their own market and then not in the local country's market.
But I think what we were talking about here was this willing buyer, willing seller concept, no?
Is your question there?
Yes, I said I thought we were talking about a willing buyer, willing seller concept, correct?
Well, I don't believe that, as I testified. I don't believe that that's the correct standard of value, but you can pursue it as if it were.
Okay. Could we put up the Pratt and Grabowski exhibit on cost of capital, please? Maybe Antonio knows which one that is. This is chapter 22. Okay.
Do you have an exhibit number?
I'm just looking for that now. I thought we had it. I think this is. I think it's cited in the footnotes of his report. So. CL. I apologize for the technical difficulties here. I think that in your book, which is cited in your statement on the cost of capital, you state that using the acquiring firm's overall cost of capital as the required return in valuing an acquisition.
But where are you, sir?
Let's see.
I'm sorry, could you show him what you're referring to?
Yes, why don't you just show him this? Just that page right there.
Could the tribunal see that?
Yes, of course. Jose Antonio, do you have copies of all this?
Is this a document that is on the record?
This is cited in his report.
But I don't believe what you're showing him is in the record, correct?
Mr. Foster, I believe that if you look in the report, you'll see that this book is referred to. I think it's entirely fair game for me to ask him a question based on his own book when he's cited it in his paper.
There is a citation to the book, but this passage has never been submitted in the record.
Well, if you may I proceed?
I think you should proceed to the extent that the report of the statement, the opinion of Mr. Pratt has been based on it.
All right, thank you. I think if maybe I can cure Mr. Foster's problem, if I may. Why don't we say that this is not an exhibit to be used in the record, but I'll just use it as a demonstrative exhibit. This is something that he has said, and I think it's fair to ask him about it. We're addressing the cost of debt, and
This simply is not in the record.
If it's not on the record, can you please phrase your question in terms of the statement to which it relates that is on the record, that is his opinion?
Mr. Pratt.
In the meantime, if you'll take it down.
You're the author of Cost of Capital, Applications and Examples, 3rd edition, with Mr. Grabowski, are you not? Yes.
Yes, I am the author of that. Currently, it's in the 4th edition.
Yes, sir, I'm aware of that. And do you recall writing in that book that the correct cost of capital matches the risks in the expected cash flows being valued, and that one of the common mistakes in valuation is using the acquiring firm's overall cost of capital as the required return in valuing the acquisition?
Yes.
Okay, thank you very much.
Now, that does not apply here.
And I think that it should apply, no?
Pardon me?
It should apply here, no?
No, there's no acquiring firm. There's no merger.
But again, I think you're slipping into this question of whether Guatemala should be incentivized or not. If we were talking about a pure valuation, we would be looking at a willing buyer, willing seller situation.
If Mr. Deverwas could ask a question as opposed to making statements, it would probably move things along.
Is that not correct?
Well, you haven't established a connection. There was no acquiring company.
Dr. Pratt, can we just go back again to the very beginning? You were asked, and I think this is back in the description of your assignment, to determine the discount rate at which these projected lost profits should be discounted back to present value as of December 31, 2006, in conjunction with this claim, correct?
Correct.
And I think we talked about the Chorzo factory standard and the attempt to find value being trying to find the fair market value of Ferrovias, correct?
Well, counsel, you did, but I don't think I ever did.
Well, I think if we went back and replayed the record, I think we would find that in the beginning of your testimony, you had accepted that proposition. Isn't that right?
I don't think so.
All right. Well, I think the tribunal can read the record for itself and make their own decision. Now, let's talk about the evidence supporting the 7.08% that you used. You based that on the value of a promissory note. Could we please put up SPV 03? This is an amended and restated line of credit promissory note, which was attached to your report, sir?
Yes.
Is that right? And could you read me the date on the promissory note?
February 13, 2002.
Thank you. And you were asked to value Ferrovias in September 2006, the time of the taking. So this is out of phase, isn't it?
Well, this particular note is, but the source of our rate was the financial statements of our RDC.
Why was it necessary to attach this note to your report if this was not the foundation for your rate? I think you included it in the footnote to justify this rate, didn't you?
I don't know.
Could we look at page? Well, we'll. I don't want to interrupt the flow, so we'll come back to that question in a minute when we're out of this document and into the next. Let's continue looking at the note. Do you see the paragraph that says for value received?
Yes.
And who are the makers of this note as you read it in that paragraph?
On first glance, it would seem to me that it's Henry Posner and Railroad Development Corporation.
Correct. And could you continue on in the parenthetical? Does it say that they're jointly and severally the maker?
Yes.
Okay. So whose debt were you evaluating when you looked at this note? Mr. Posner's or RDC's?
combined.
It's joint and several,
Yeah,
correct?
joint several.
Right. So this is not the pure credit of RDC, is it?
No, it's not.
Thank you. And when you're building a weighted average cost of capital to discount over 42 years, you would properly use a long-term borrowing rate, would you not?
Yes.
All right. Let's take a look at the term of this promissory note. Could we scroll down to Clause E on page 6, please? Focusing on Clause E, this is a demand note, isn't it, Dr. Pratt?
Yes.
And that means it's due and payable on any given days, not in 5 years, not in 10 years, not in 20. It could be due tomorrow, correct?
Yes.
So it's not a long-term borrowing rate being reflected in this note, is it?
Well, it may be. It may be. Some people use demand notes for long-term notes.
All right. Let's now take this down and go back to Dr. Pratt's report. If we could go to page 5, please. Looking at the paragraph in the middle of this page called Cost of Debt for Railroad Operations. Do you see that, sir?
Yes.
Okay. It says, as cost of debt for railroad operations, we use the interest rate paid by RDC on its lines of credit that was outstanding as of the valuation date. Footnote 4. And could we scroll down to footnote 4, please? Footnote 4, amended and restated line of credit promissory note between Henry Posner III and Railroad Development Corporation and Dollar Bank, Federal Savings Bank, February 13, 2002, Exhibit SPV 03, correct?
Yes.
And that's the note we just looked at, correct?
I think so. And here it's described as a line of credit promissory note. So it's there it's indicated that it's a line of credit. It's not intended to be short term.
I see. This is the evidence on which you're basing this rate that you have selected, correct?
Yes.
Okay.
Well, yes, and I base mine on the footnotes to the financial statements, but evidently this is the underlying document.
Thank you. The footnotes in which financial statements, sir? The RDC,
RDC.
financial statements?
Yes.
All right. Could I just note for the record that we requested the RDC financial statements, and what we were given was completely blacked out except for 1 or 2 lines. So I don't know that this is a foundation on which Dr. Pratt's opinion could be based.
I would note also for the record that they didn't challenge what we gave them.
I think, Mr. President, that the witness should not be relying on documents that haven't been made available to us, just as a matter of equity in the proceedings. All right. Well, if the tribunal would like to rule on it, I'll wait.
I was going to ask Mr. Foster his views.
They asked for financial statements. We gave them financial statements that were redacted except as to FVG. They had the opportunity to ask for additional information if they wanted it. They've had Dr. Pratt's report for a long time. This is a long-term line of credit financing. As is obvious, the report says that it was still in existence as of the time of the valuation date. It's dated 2002. It's been there. It had been there for over 4 years as of the time of the valuation date.
With respect, counsel is arguing the merits of the dispute at this point. It's a question of fundamental fairness, Mr. President. The expert can't be relying on documents that we cannot have access to so that we can properly cross-examine him.
Now, as I understand it, certain financial statements redacted have been given to you. Is the opinion of Dr. Pratt based on those statements as redacted, or on also the part that have been redacted? I think that's the question in terms, if you are going to judge on the fairness of the issue.
I'm afraid I don't know the answer to your question as to whether the reference to the interest rate was part of the redaction or not. We can determine that.
I think the tribunal, for the purposes of the examination of Dr. Pratt, who is here at this moment, we will continue as is, but on the assumption that the other party, meaning the party representing Guatemala, will receive all the documentation on which Dr. Pratt has made his evaluation.
We'll check, and if it is redacted, if the note he's talking about is redacted, we'll provide it.
With all due respect, Mr. President, we lose the opportunity to cross-examine him on whatever they provide, and I think, if I showed him these redacted statements, I mean, they literally are pages and pages of black. There's nothing in here that, he could, rely on, and I don't see how this in any way cures the problem.
You had the redacted statements, you had the opinion of Dr. Pratt, and you had not raised the issue. So from the point of view of the tribunal, at this point, I mean, if it's true, you may lose to cross-examine the expert on those parts that are redacted, if his opinion is based on that. But that is also on your side, not having questioned the matter earlier. So from the perspective of the tribunal, I repeat what I said before, we will continue as is. You proceed to your cross-examination on the basis of the information that is available. The other party has agreed to give you the information redacted to the extent that there is the information on which Dr. Pratt has based his statement, and you will have an opportunity later on in the proceedings, to comment as necessary afterwards. After you receive it, there will be you know, where is the closing statement, if you receive it before or in post-hearing statement, etc. So certainly you would have that opportunity.
I'd like to just state for the record, Mr. President, that we didn't learn until today that Dr. Pratt was intending to rely on these RDC statements, so there's no way we would have known to press the point. He's essentially being allowed to amend his statement and provide a new foundation for it after the fact. We will proceed, but I think that it's not cited, these financials are not cited in his statement, and so we do really feel surprised by this.
I just also for the record, I believe that what we're going to find is that the financial statement refers to this note. I think that's what we're going to find. I think they're merely cumulative, but we'll see when we look at it.
Thank you, Mr. President.
We have taken note of everything that has been said. And please, Mr. Debevoise, continue.
Dr. Pratt, you have a disagreement with Dr. Spiller on the weighting to be applied in the weighted average cost of capital calculation between the real estate business and the railway business. In this regard, you have weighted according to the EBITDA developed by Mr. Thompson, which in turn depends in part on Mr. McSwain's analysis of real estate revenues. So if the tribunal were to find Mr. McSwain's calculations speculative and unsubstantiated, there might be a corresponding impact on the weighting factor, correct?
Yes, that's correct.
Okay.
It would be minor because the railroad weighting is the railroad cost of capital is so close to the real estate cost of capital that any change would be minor.
So essentially you're saying that the dispute between you over 92.8 versus 50/50 is also minor.
Yes.
Thank you. I have no further questions, Dr. Pratt.
Thank you, Dr. Pratt. Mr. Foster.
Just one question. Does modern economic theory also take into account policy considerations, Dr. Pratt?
Counsel, I hate to ask you a question back, but I'm going to whose policy considerations?
General, does modern economic theory take into account policy considerations such as the use of economics to influence behavior?
Yes.
That's all I have.
Let me ask my colleagues if they have any questions.
I have one question to clear up an issue in which I thought I heard different answers to the same issue. And that is the discounted cost of capital, the gold standard, and the issue of fair market value, a willing buyer and willing seller. At one point, I thought you said that that was the appropriate standard, and then at another that it was not. Perhaps you might explain to the tribunal.
Well, the tribunal, it's up to the tribunal to make that decision. Evidence has been presented on fair market value. At least the adequate numbers have been presented so that the tribunal can make the determination as if it's fair market value.
Yes, sir, but what would the key factor for the tribunal be to make that judgment?
They should they should subtract either the discounted, either the result from the discounted cash flow or the embedded costs.
And is that what Mr. Thompson did?
No,
That's different than the amortization issue.
yes. That's different than the amortization issue. The amortization, although it's completely amortized, there's a matter of timing difference, which makes the net come out differently. So, if the tribunal determines that the lost profits are the only thing that should be taken into consideration, comes out to between 30 and 32 million. If the tribunal decides that only the sunk costs become relevant, it should take out, the answer is about 42 million.
And then if one were to determine that both might be appropriate,
If both might be appropriate, the number at the end of my report is valid.
which is,
I'm not finding it readily, but it's approximately 62 million.
62 million is up
Yeah.
to 60. Okay, and then just, again, I want to reflect on this. You went into the issue of whether, if there were a finding of an illegal expropriation,
Yes,
that you would want to discourage that, and that would lead to combining both.
yes.
But it's not clear on what basis the tribunal, from your perspective, if we decide not to include both, but either the cost, the lost profit, or the sunk costs, either one or the other. I'd like to know your thinking of what would drive or should drive the tribunal to one or the other of those estimates.
I think that the sunk costs would be more appropriate because they're a known fact.
Whereas the profits are more speculative.
Yes,
And the sunk cost, you took the $15 million that had already been invested as the basis for that?
well, yeah, and I moved it forward by 12.9% per
Yes.
year.
Yeah, I understand.
Yeah. In other words, I should have set the adjusted sunk costs.
Mr. Foster, on the questions of Secretary Eisenstadt.
Nothing further.
Mr. De Bevois, on the question of Mr. Eisenstadt.
Yes, thank you, Mr. President. On this last question that you were just asked, as between the discounted cash flow and the sunk costs, I think we discussed in the beginning of your testimony that the discounted cash flow was the gold standard, correct?
Yes.
And I guess we have a situation of 8 years of losses, which you seem to attribute to the fact that this is somehow a startup. Is that correct?
I believe that was what he had already asked, as opposed to responding to a question from Secretary Eisenstadt.
Well, would you repeat the question?
Yes. I believe that I asked whether it was your view that discounted cash flow should not be used in this case because you characterize this operation as a startup, notwithstanding 8 years of operations.
Yes, there are reasons for it being a startup company after 8 years. For one thing, it had to rebuild the railroad. That took 2 or 3 years, but then there were problems with Guatemala not putting in its share of the trust fund money and not evicting squatters. So it's very much still a startup company. It's a matter of rebuilding the freight traffic from a virtual standstill.
But in the situations where the sunk costs are used, we're typically looking at a situation where the company hasn't had any operations whatsoever, and therefore the only objective things you could look at is the sunk costs. But here we have revenue projections, in fact projections that were lower than planned by the company at the beginning of the operation.
That's true. In this case, we do have, in fact, it's unusual to have a company that's still in the startup phase after 8 years, but this is the situation here.
I see. And there's been the question of the policy issue came up again. I think we discussed when we were discussing your statement, the fact that you began with a legal standard referring to the Chorzów factory case. Is that correct?
Objection. That was my question, not Secretary Eisenstadt's question. He's gone far beyond.
No, I think the Secretary Eisenstadt asked about the policy issue.
I think only Mr. Foster asked on that. If you can point out to where Secretary Eisenstadt asked the question on policy.
Yes, there was a specific reference here in my notes to the question of illegal expropriation being asked during the time of the tribunal's questions. I believe that's the policy issue. And I just have one question on this, if I may.
Just, Mr. DeBevoise, just go ahead, ask the question.
Thank you. Are you aware, Dr. Pratt, that in Chorzów factory, the court asked several questions, the famous questions 1A and 1B and question 2, and that if you applied those questions, you would be providing an economic incentive to countries not to take properties that were going to increase in value post-expropriation, so that the policy issue is addressed in Chorzów factory?
No, I'm not aware of that.
Thank you.
Before I thank Dr. Pratt, I wanted to make one comment for the record, and is that Mr. DeBevoise at one point said, in case the tribunal decides to punish Guatemala, I think that's the wrong characterization of the role of this tribunal. We are not here to punish anyone, and we don't have that capacity under the treaty under which the
I-
tribunal was established.
I wouldn't debate that comment.
Mr. De Bois.
Thank you, Mr. President, for making the distinction.
Mr. Pratt, thank you so much for being with us.
Thank you.
We will adjourn now and reconvene at 2 o'clock. I wanted to ask about Dr. Spiller. I remember that there was an issue that he needed to testify today. Is there any issue time-wise during the afternoon?
Mr. President, no, he is available all day long
Oh,
today.
all day. Okay. Thank you. So I see you at 2:30. Sorry, at 2 o'clock. At 2 o'clock. Sorry.